Good evening. How is everybody doing? Great to be learning with you on a Saturday night. Let's light up the darkness as we open a new tractate, Tractate Makkos, the 25th volume of the Talmud. In some ways, a continuation of Sanhedrin, still speaking about things that come out of a court, out of a beis din, a rabbinic court, and talking about conspiring witnesses. Then we'll be talking about the punishment of exile, which would be to a city of refuge. And then, more specifically, on the name of the tractate, Makkos means lashes. So when are lashes going to be an appropriate punishment administered by a rabbinic court? The hour is late, always in awe of the people on the East Coast who tune in during the summer. And a reminder, we will not have class tomorrow, Saturday, nor Monday, because I'm traveling to a film festival, Vancouver Jewish Film Festival, for a screening of Guns N' Moses, back on Tuesday at the regular time, 6 p.m. Pacific. Okay, beautiful. Opening tractate Makkos. Like every tractate, opens on page 2. Rav Steinsaltz right away gives us the verses in the Torah that are going to be very relevant in this chapter. Deuteronomy 19, verses 16 through 21. If an unrighteous witness rises up against any man to bear perverted witness against him, the two men between whom the dispute is shall stand before the Lord, before the priests and the judges who shall be in those days, and the judges shall inquire diligently. And if the witness is a false witness and has testified falsely against his brother, you shall do unto him as he conspired to do to his brother. Conspired because there are always two witnesses, but only by the minimum of two witnesses shall a matter be established. And so shall you remove the evil from your midst. And those that remain shall hear and fear, and shall henceforth commit no more such evil in your midst. And your eyes shall not pity, life for life, eye for eye, tooth for tooth, hand for hand, foot for foot. So, we've already seen this principle a bunch of times. Conspiring witnesses, they would be rendered conspiring witnesses because two more witnesses come and say, well, at the time and place where you claim to have witnessed the defendant in this case doing such and such, you could not have been there because you were with us in another place at that time. That would render the conspiring witnesses guilty of this crime, and then they should suffer the same fate that the defendant would have suffered if he was convicted of the crime that the conspiring witnesses came to testify falsely about him. Well, the problem is, what if the accusation was proven according to the testimony of the conspiring witnesses? So then, there would have been a consequence, a heavy consequence for that defendant, the one who was being testified about. But that consequence might not be applicable. It might not work to say that the conspiring witnesses will suffer the same consequence, because maybe it's something that only applies to a priest or only applies to a male but not a female, etc. And so you can't render that same consequence onto the conspiring witnesses. So then what do? What's the word I'm looking for? Spoiler alert. The bottom line is Makkos, right? That's when you would apply lashes instead. On the other hand, right, if the conspiring witnesses were testifying in a murder case where if their testimony was believed, then it would be a death penalty offense for the defendant, then that death penalty will apply to the conspiring witnesses. But again, what if the same type of death penalty can't be possibly applied for a reason, as we'll see, then what do? Okay, so page 2, Tractate Makkos, Mishna number 1 of chapter 1. How are witnesses rendered conspiring witnesses? This applies in a case where two witnesses came before the court and said, we testify with regard to so-and-so, who is a priest, that he is the son of a divorced woman or the son of a chalutza, right? A woman who performed chalitza rather than marry her brother-in-law after the death of her husband. both becoming a chalitza or being a divorced woman mean that a priest, a Kohen, is not permitted to marry her. And if he does, then the sons that they have of that union are Kohanim, but they are disqualified from serving in the temple. That's called a halal. So the question is, if the conspiring witness, let's say he's not a Kohen, most likely he's not, but he testifies that, oh yeah, this priest, he married a divorced woman, or this man who is claiming to be a qualified priest, actually his mother was a divorced woman when his father married her, so he's disqualified. Okay, so if the testimony were believed, that priest would be rendered a halal. But you can't do that to the conspiring witness who's not a Kohen, who's not a priest at all. You can't say he's now going to be a disqualified priest. Makes no sense. So that's the kind of question we're asking here. So if a second set of witnesses testifies in court and renders the first set a conspiring witness, renders them conspiring witnesses, one does not say, with regard to each of the conspiring witness, that this witness shall be rendered the son of a divorced woman or the son of a chalutza in his stead. Rather, he receives 40 lashes as punishment for his false testimony. And recall that we have two prohibitions in the Torah. One is you shall not be a conspiring witness, and then you shall suffer the consequence the defendant would have suffered. And the other is you shall not bear false witness. And the standard punishment for that is lashes. Likewise, in a case where two witnesses came before the court and said, we testify with regard to so-and-so that he is liable to be exiled. When does exile happen? When you commit an action that results in somebody else dying. It's not murder, right? It's not murder, intentional murder, because that's not what happened. It was some kind of negligence. On the other hand, it wasn't a total accident in which there would be no consequence. That's often referred to as something that happened due to circumstances beyond your control. That's an accident, and there's no liability. But somewhere between intentional murder and accident is some kind of negligence called manslaughter. In that situation, the person flees, has to go to a city of refuge, and can't leave the city of refuge for the rest of his life unless the Kohen Gadol, the high priest, predeceases him, in which case he could leave. But exile to the city of refuge, on the day it happens, he has to flee there. Then he has to come back and have a trial, and then if indeed it was the circumstances warrant exile, then he goes back to the city of refuge. There's a trial for that, and there are witnesses for that. Likewise, in a case where two witnesses came before the court and said, we testify with regard to so-and-so that he is liable to be exiled to a city of refuge for unwittingly killing another, based on Numbers 35:11, and a second set of witnesses testifies in court and renders the first set conspiring witnesses, one does not say with regard to each of the conspiring witnesses, this witness shall be exiled in his stead. Rather, he receives 40 lashes, right? And this is because these sentences that the rabbinic court could issue, what is their purpose? Punishment, deterrence, and atonement, right? They serve as an atonement for the person who is sentenced to lashes or to the death penalty, also has an atonement component, or exile, as well as punishment. Or punishment has to fit the crime, and a deterrent effect so that other people won't commit that same crime. Right now, and that's why, because there's those three components, it can be that the conspiring witnesses, it doesn't fit into the same category in the same way that we just saw. That's the Mishnah. Now the Gemara. The Gemara analyzes the opening question of the Mishnah. But based on the cases discussed in the Mishnah, the Tana should have asked, how are witnesses not rendered conspiring witnesses? Right? The Mishnah was worded as, how has somebody become a conspiring witness? But we just said they're not rendered conspiring witnesses because we're going to do a different sentence to them. We're going to issue lashes. The standard punishment for conspiring witnesses is the punishment that they conspired to have inflicted upon the subject of their testimony. The Mishnah cites anomalous cases where their punishment does not correspond to the punishment that they sought to have inflicted on the defendant. So the Gemara asks, and furthermore, from the fact that the Tana teaches in a Mishnah cited later on page 5a, But if the second set of witnesses attempted to render the first set conspiring witnesses and said to them, how can you testify to that incident when on that day you were with us and in such a place? Then these first witnesses are conspiring witnesses. And one learns by inference from the final phrase in the cited passage, these are conspiring witnesses, that those enumerated in the Mishnah here are not conspiring witnesses. So the Gemara answers both questions. The Tana is standing there in his studies at the end of Tractate Sanhedrin, which immediately precedes Tractate Makkos, and Makkos is often appended to the end of Sanhedrin. In fact, it used to be sometimes that when the Talmud was published and put together, Makkos was part of Sanhedrin, though now we consider it a separate tractate. Now, the Mishnah there on Sanhedrin on page 89a teaches all those who are rendered conspiring witnesses are led to be executed with the same mode of execution with which they conspired to have their victim executed, except for conspiring witnesses who testified that the daughter of a priest and her lover committed adultery, where the daughter of the priest would be executed by burning. But the conspiring witnesses would not receive that death penalty. They would receive the same death penalty that the lover of the daughter of the priest would receive, and that would be strangulation. So in that case, the conspiring witnesses are not taken directly to be executed with the same mode of execution that they sought to have inflicted on the woman. Rather, they are executed with a different mode of execution, the one that they sought to have inflicted on her lover. Therefore, the Tana continues in this first Mishnah in Makkos, and there are conspiring witnesses with regard to whom the court does not apply the laws governing the punishment in standard cases of conspiring testimony at all. Not right. It's not just a different form of death penalty in the cases we just named. Right. I mean, it's completely different. The punishment would have been that this priest is rendered disqualified. The punishment for the conspiring witnesses is going to be lashes. Or the punishment for the manslaughter would have been exile. The punishment for the conspiring witnesses who sought to have him exiled, but for them, it's going to be lashes. Totally different punishment. Rather, in these cases, they receive lashes, 40 lashes. How and in what cases is this applied? Have we spoken all the cases? Maybe there's more cases. What is the principle when we go to lashes rather than what the conspiring witnesses sought to impose on the defendant? And how and in what cases is this applied? And this is applied in a case where two witnesses came before the court and said, we testify with regard to so-and-so that he is the son of a divorced woman or the son of a chalutza. So one does not say with regard to each of the conspiring witnesses that this witness shall be rendered the son of a divorced woman or the son of a chalutza in his stead. Rather, he receives 40 lashes. And the Gemara asks, from where is this matter derived, that the court does not punish the witnesses with the punishment they sought to have inflicted and disqualify them from the priesthood? Let's say it was a priest who came as the witness. There we would be able to impose the same punishment. We could disqualify him the way he sought to disqualify a fellow priest. But it sounds like whether he's a priest or he's not a priest, if he testifies that that other guy is disqualified, the punishment is going to be lashes. Why? Rabbi Yehoshua ben Levi says that Rabbi Shimon ben Lakish says this is derived from a verse. As the verse states, Deuteronomy 19:19, and you shall do to him as he conspired, from which the Gemara infers it is done to him, but not to his offspring. Rendering the witness a halal would disqualify his sons as well, right? A Kohen who's the son of a halal is also a halal. So if the one who conspired to disqualify another priest, which would result not only in that priest being disqualified, but his sons too. If you did it to him, right, if he was a priest testifying falsely and you disqualified him, okay, maybe he deserves that, but do his sons deserve that? No. The Gemara challenges, so let the court invalidate the witness and not invalidate his offspring. Can't we just say special measure? He's a halal because he was a conspiring witness, but we will not disqualify his sons. And the Gemara explains this too would not accord with the directive in the verse. As based on the verse, we require that the punishment be as he conspired to do. And that is not the case here. as the witness conspired to disqualify the subject of his testimony and his offspring, right? He sought to falsely disqualify a priest, let's say a fellow priest, and if he succeeded, then that man's sons would also be disqualified. So we can't impose the same punishment on him that he sought to impose on the subject of his testimony. Bar Pada says that this alternative form of punishment is derived through a kal v'chomer inference, meaning that we go to lashes and not try to do the same thing that he was trying to do to another person. If one who actually disqualifies another from the priesthood, i.e. a priest who fathers a son with a divorcee, disqualifies their son from the priesthood, but he is not himself disqualified from the priesthood, right? A priest who marries a divorcee and has a son by her, so his son is a halal. While he's married to the divorcee, he's a halal. But if she dies, or if he divorces her and he's no longer married to her, he's no longer a halal. He would be qualified to serve as a priest at that point when he's no longer married to that divorced woman, even though his son by that woman would always be a halal, right? So if the one who actually disqualifies another from the priesthood, the father, is not himself disqualified permanently, then with regard to this witness who came to disqualify another from the priesthood, but was unsuccessful, because he was rendered a conspiring witness, so he was unsuccessful. He never actually disqualified his fellow priest from anything. Isn't it logical that he should not be disqualified also? So Ravina objects to this reasoning. Well, if so, that the failure of the conspiring witnesses to achieve their objective is the consideration at the basis of this kal v'chomer inference, well, then you have thereby rendered the law of conspiring witnesses obsolete. As one could claim, well, if one who stones another, meaning somebody who came to testify that another is guilty of murder and should be stoned to death, but he was rendered a conspiring witness, and therefore he was not successful in having the defendant stoned, well, then we should not apply the punishment that he sought to impose on the other. And we don't say that. We say you are going to be stoned to death the way you sought to do the other. The fact that you were unsuccessful as a conspiring witness does not excuse you from the punishment. So we can't say that because he was unsuccessful is the reason that we wouldn't impose that outcome. And if one who stones another, i.e. who testified that another is liable to be executed by the death penalty of stoning and was rendered a conspiring witness after that person was executed, is not stoned, as the law is that the conspiring witnesses receive the punishment that they conspired to have inflicted and not the punishment that they actually inflicted, then with regard to a conspiring witness who came to stone another and was unsuccessful and did not stone him, as he was rendered a conspiring witness before that person was executed, isn't it logical that he should not be stoned? And the Gemara concludes, rather, it is clear as we answered initially. And you shall do to him as he conspired. This should be done to him, but not his offspring. In this case, about witnesses who came to disqualify a priest, or let's say a Kohanim who came to falsely disqualify a fellow priest, we still don't do to them what they would have done to him because we don't want to disqualify their children who are innocent. New subject. The Mishna teaches that in a case where two witnesses came before the court and said, we testify with regard to so-and-so that he is liable to be punished with exile, right? That would be a manslaughter case. One does not say that these witnesses shall be exiled in his stead. Rather, they receive 40 lashes. And the Gemara asks, from where is this matter derived? And Reish Lakish says it is derived from a verse. As the verse states, with regard to an unwitting killer, and he shall flee to one of the cities. Deuteronomy 19:5. And the Gemara infers, he shall flee, but conspiring witnesses shall not. Rabbi Yochanan says it is derived through a kal v'chomer inference. If the killer who performed an action that, had he done so intentionally, he would not be exiled for it, even if he were not sentenced to death. For example, because there was no forewarning. Then, in the case of the conspiring witnesses who did not perform an action as their conspiracy was exposed and their testimony rejected, even if they testified intentionally, isn't it logical that they should not be exiled? Again, very interesting, right? Who qualifies for exile? The manslaughter, right? The negligent murderer. What about an intentional murderer who gets off on a technicality, right? There was a lack of warning, and so they're not going to be able to impose the death penalty on him. So why don't we at least impose exile on him? But that's not the way that the law works. Exile is only for the manslaughterer. The Gemara challenges, but that distinction provides support to the contrary. Could this not be derived through a logical inference with regard to one who performed an action, i.e. who killed a person? If he did so intentionally, let him not be exiled so that he will not have atonement for his action, and he will instead receive harsh punishment at the hand of heaven. That's that atonement component of punishment. When a person receives lashes, or even when he receives a death penalty, certainly when he receives exile, it's not only a punishment, it's not only a deterrent for others, it's also an atonement. It's actually a benefit to you to be punished, because if you don't make an atonement while you're alive in this world, even with your last moments, if it's a death penalty, well, then you go to the next life, to the world of souls, with your sin upon you. And if you didn't make the atonement here, maybe you'll be disqualified from Olam Haba. Maybe you're going to have to spend a lot of time in Gehenna. Maybe you're going to have a very severe punishment in Gehenna. Having your atonement made for you here, making your atonement here, is a benefit. Right? So with regard to the conspiring witnesses who did not perform an action, even if they testified intentionally, let them also be exiled so that they will have atonement for their misdeed of testifying falsely. And the Gemara concludes, rather, it is clear in accordance with the explanation of Reish Lakish, and he shall flee to one of the cities, he, but not the conspiring witness. Ula says, from where is an allusion in the Torah to conspiring witnesses derived? And the Gemara asks, is an allusion to conspiring witnesses required? But isn't it written explicitly? And you shall do to him as he conspired. Deuteronomy 19:19. Rather, Ula's question is this. From where is an allusion in the Torah to the law that conspiring witnesses are flogged in certain cases? Where do we know that? That's not written explicitly in the Torah. So this is derived from that which is written. If there is a quarrel between people and they come to judgment and the judges judge them, and they vindicated the righteous and condemned the wicked, and it shall be if the wicked is deserving of lashes. So there are cases where lashes are appropriate, and the Torah does not spell out explicitly what are all the cases that result in lashes. Basically, lashes are appropriate where somebody violates a prohibition, and there's going to be some other stuff like this. But this is largely, up to the sages, up to the elders in each generation, up to the judges. Lashes is a kind of, sort of jackknife, like a jack of all trades. A knife. What's the word I'm looking for? An all-purpose tool, right? Or rather, a multi-purpose tool. Lashes are a multi-purpose tool for consequences in judgment. Right? Shall be so ostensibly. So let's repeat that verse. Deuteronomy 25 verses 1 and 2. If there is a quarrel between people and they come to judgment and the judges judge them and they vindicated the righteous and condemned the wicked, and it shall be if the wicked is deserving of lashes, ... So ostensibly this verse is difficult. Is it due to the fact that they vindicated the righteous that they condemn the wicked, and it shall be if the wicked is deserving of lashes? In most disputes, the fact that one party is vindicated does not necessarily lead to lashes for the other party, right? Many cases probably most cases that are brought before a Beis Din are about money, not about lashes, monetary damages, right? So rather, the verse is addressing the case of witnesses who, through their testimony, condemned the righteous, and other witnesses came and vindicated the original righteous person and rendered these first set of witnesses wicked, conspiring witnesses. In that case, the verse states, and it shall be if the wicked is deserving of lashes, indicating that lashes are an appropriate punishment for conspiring witnesses. The Gemara asks, and why not derive the law that conspiring witnesses are liable to receive lashes from the prohibition, Exodus 20, verse 13, you shall not bear false witness against your neighbor? And the Gemara answers, one is not flogged for violating that prohibition, due to the fact that it is a prohibition that does not involve an action, meaning with your hands, as one violates it through speech rather than action. And the principle is, for every prohibition that does not involve an action, one is not flogged for its violation. Therefore, it was necessary to derive the law from the verse, and they vindicated the righteous. The sages taught in a baraisa 4 matters were stated with regard to conspiring witnesses, i.e., there are 4 cases in which their punishment deviates from the norm. They are not rendered the son of a divorced woman or the son of a chalutza, as we've discussed. They are not exiled to a city of refuge, as we discussed. They do not pay the ransom. This is in the case of an ox that was known to be a goring ox, and the owner was warned, and then the ox gores again and kills someone. Now the owner has to pay a ransom, otherwise his life would be forfeit. That's why it's called a ransom. And they are not sold as a Hebrew slave in a case where they testified that one stole property and that he would be sold into slavery if he lacked the means to repay the owner, right? Very interesting that if you conspired, two conspiring witnesses came and testify against a poor person that he owes a lot of money, right, and he can't pay it, so he would be rendered a Hebrew slave who's going to have to serve for 6 years. That seems like, why not make the conspiring witnesses have to suffer that same fate? But that is not one of those cases where we would do that. The sages said in the name of Rabbi Akiva, they also do not pay based on their own admission. If they were rendered conspiring witnesses in one court, and before that court managed to collect the payment that they owed, they appeared in a different court and admitted that they had been rendered conspiring witnesses, they are exempt from payment. The Gemara elaborates, they are not rendered the son of a divorced woman or the son of a chalutza, as we stated and explained earlier. And they are not exiled to a city of refuge, as we stated and explained earlier. And they do not pay the ransom, as these sages hold that the ransom paid by one whose ox killed another is atonement for him, as he is liable for the actions of his animal, and it is not payment of damages. And these conspiring witnesses are not subject to a need for atonement, as their ox did not kill anyone. The Gemara asks, who is the Tana who taught that the ransom is a form of atonement rather than damages? There's also damages, but the ransom is a form of atonement. Rav Chisda says, it is Rabbi Yishmael, the son of Rabbi Yochanan ben Baroka, as it is taught in a baraisa with regard to the verse concerning a case where the ox of one person gored another. Quote, if ransom is imposed upon him, and he shall give the redemption of his soul. Exodus 21:30. And the term his soul means the value of the victim, i.e., the owner of the ox must pay the heirs of the deceased his value as it would be assessed were he sold as a slave in the market. Rabbi Yishmael, son of Rabbi Yochanan ben Baroka, says the term his soul means the value of the one liable for the damage. And what? Is it not that they disagree with regard to this principle? That one sage, the rabbis, holds that the ransom is monetary restitution for the damage that his ox caused the victim, and the other sage, Rabbi Yishmael, holds that the ransom is atonement, as he thereby redeems his own soul from death at the hands of heaven. Rav Papa says, no, perhaps everyone agrees that the ransom is an atonement, and here it is with regard to this matter that they disagree. One sage, meaning the rabbis, the majority, holds that we assess the payment in terms of the value of the victim, and the other sage, Rabbi Yishmael, holds that we assess the payment in terms of the value of the one liable for the damage. And the Gemara asks, what is the reason for the opinion of the rabbis, who abandon the straightforward meaning of the verse? And the rabbis derive it in the following manner. Imposition is stated below with regard to one whose ox killed another. If ransom is imposed upon him, and imposition is stated above in the case of one who struck a pregnant woman, causing her to miscarry, he shall be punished, as the husband of the woman imposes upon him. So just as there with regard to the miscarriage, it is in terms of the value of the victim, the fetus, that we assess the payment, here too, in the case of the ransom, it is in terms of the value of the victim that we assess the payment. And what about the other side of the argument? Rabbi Yishmael, the son of Rabbi Yochanan ben Baroka, says, and he shall give the redemption of his soul. That is what's written, indicating that the sum is based on the value of the one seeking atonement. And the rabbis explain, yes, the phrase redemption of his soul is written, and the payment functions to redeem his soul. Nevertheless, when we assess the sum of the redemption payment, it is in terms of the value of the victim that we assess the payment. Now, the Baraisa teaches conspiring witnesses are not sold as a Hebrew slave in a case where they testified that one stole property. Rav Hamnuna thought to say this statement applies only in a case where the falsely accused has means of his own to repay the sum of the alleged theft, as since, had the testimony been true, he would not have been sold for his transgression. The witnesses too are not sold when they are rendered conspiring witnesses. But in a case where the falsely accused does not have means of his own and would have been sold into slavery had their testimony been accepted, then even if the witnesses have means of their own, they are sold, as they sought to have slavery inflicted upon the subject of their testimony, which seems quite fair and reasonable to me. Rava said to him, and let the witnesses say to the person against whom they testified, if you had money, would you have been sold? Well, the fact that we have money shouldn't be held against us, so we too will not be sold. Since they have the means, they can pay the sum that they owe and not be sold as slaves. So rather, the Gemara proposed an alternative formulation of the statement of Rav Hamnuna. Rav Hamnuna thought to say, this statement applies only in a case where either he, the falsely accused, or they, the witnesses, have the means to pay the sum. But in a case where neither he nor they have the means, then the conspiring witnesses are sold as slaves. In that case, had their testimony stood, the alleged thief would have been sold into slavery, and they too lack the means to pay the sum that they are liable to pay as conspiring witnesses, therefore they are sold. Rava said to him, no, that is not so. As the merciful one states, and he shall be sold for his theft, Exodus 21:30, from which it is inferred for his theft, but not for his conspiring testimony. It is taught in the Baraisa, the sages said in the name of Rabbi Akiva, they also do not pay based on their own admission. And the Gemara explains, what is the reason for the opinion of Rabbi Akiva? He holds that money paid by a convicted, conspiring witness is a fine, kenasa. And the principle is, one does not pay a fine based on his own admission. One pays a fine only on the basis of testimony. Rabbah says, no, that it is a fine, as these witnesses did not perform an action and caused no actual damage, and yet they are executed or paid depending on the nature of their testimony, indicating that it is a fine rather than a monetary restitution. It is a punishment that makes an atonement and that we impose on them, even though they didn't commit the original crime. The crime they committed was conspiring and falsely testifying. Rav Nachman says, no, that it is a fine rather than monetary restitution for damages, as the money they sought to compel him to pay ultimately remains in the possession of the owner against whom they testified, and yet they pay him. Now we're on page 3a, getting a little bit of a head start on the next page, but we won't do a double daf tonight because it's so late on the East Coast. The Gemara is puzzled by this. What is the meaning of this statement? The money remains in the possession of the owner. It means that they did not perform an action, that it is identical to the reasoning of Rabbah, and it is not an additional explanation. The Gemara amends the formulation of the presentation of the statement, say, and likewise Rav Nachman says, no, that is so, as the money remains in the possession of the owner. Rav Nachman is not disagreeing with Rabbah. He merely formulates the statement differently. Apropos this statement of Rabbi Akiva and the Baraisa, Rav Yehuda says that Rav says, a conspiring witness pays according to his share. And the Gemara asks, what is the meaning of pays according to his share? If we say that it means that this witness pays half of the sum that the set conspired to render another person liable to pay with their testimony, and the other witness of the pair pays the other half, well, we already learned this in the Mishna, page 5a. So when punishing conspiring witnesses, one divides the punishment of money among them, but one does not divide the punishment of lashes among them. Each receives the full 39 lashes. Why 39, not 40? We'll get to that later. Rather, the Gemara explains the expression pays according to his share means that in a case where only one of the set was rendered a conspiring witness, the law is that he pays his half of the sum. And the Gemara asks, and does he pay at all in that case? But isn't it Torah Baraisa? A conspiring witness pays money only when both were rendered conspiring witnesses. If only one was rendered a conspiring witness, he does not pay. And Rav says this statement is not referring to a case of conspiring witnesses. Rather, Rav's statement applies to the case of one who says, it was false testimony that I testified. The Gemara asks, he admits that he testified falsely. Is it in his power to have this statement accepted by the court? That runs counter to the principle. Once a witness stated his testimony, he may then not state a revision of the testimony. I'm almost done. Questions or comments? Get them in now. So the Gemara answers, rather, Rav's statement applies to the case of one who says, we testified and were rendered conspiring witnesses in such and such a court. Since he was already convicted as a conspiring witness, it is as though he is admitting an obligation to give monetary restitution, and he is therefore liable to pay his share. And the Gemara asks, in accordance with whose opinion is this law? Is it not in accordance? It is not in accordance with the opinion of Rabbi Kiva. Since if it were in accordance with the opinion of Rabbi Kiva, doesn't he say a conspiring witness also does not pay based on his own admission? So the Gemara answers, rather, Rav's statement applies to the case of one who says, we testified and were rendered conspiring witnesses in such and such a court, and we were rendered liable to pay a specific sum of money. In that scenario, Rabbi Kiva would concede that one who pays on the basis of his own admission, once the court rendered him liable to pay a specific sum, his admission is not that he is liable to pay a fine, in which case he would be exempt. Once the court actually instructed them to pay, the debt has the status of any other monetary restitution, and one does pay monetary restitution based on his own admission. Different laws apply to monetary restitution than apply to fines. And the Gemara explains the novel element in Rav's statement. It might enter your mind to say that since he is unable to render his fellow witness liable to pay based on his admission, as only the testimony of two witnesses is capable of doing so, he too is not liable to pay based on that admission. And to counter this, Rav teaches us that his admission that he owes money renders him liable to pay. And that concludes our discussion of Mishnah number 1 here in chapter 1 of Tractate Makkos. We'll pick it up, God willing, on Tuesday at the regular time, 6 p.m. Pacific. No class Sunday and Monday because I'll be on the road. Tuesday, we'll pick it up at 6 p.m. Pacific with Mishnah number 2 here in chapter 1. Just 2 question comments. Luis, why does each chapter open on page, not each chapter, each tractate opens on page 2? Oh, great question. I know this. I've researched. I've known the answer, and I can't remember it right now. I'll get you an answer. But it is definitely a tradition that every tractate in published editions of the Gemara begin on page 2. It has been for a long time. I'll look it up. I'll speak it on Tuesday. And finally, Joseph, how do we reconcile that eye for an eye is not a literal retribution but payment for damages with the law of the punishments for conspiring witnesses? Well, because in the law of conspiring witnesses, outside of these exceptions, the Torah mandates specifically, you shall do to him as he conspired to do to his brother. But these exceptions are for the exact same reason why eye for an eye, tooth for a tooth, is not something literal that we impose, and rather we use it with money damages. The reason being, that if somebody breaks somebody else's hand in a fight, right, and the guy, whose hand was broken, is, let's say, a driver who can easily drive with his left hand, but the one who broke his hand is a pianist who, if his hand is broken, can't make a livelihood, then doing to him what he did to that guy would not produce the same consequence. And of course, there's many, many examples of that. And therefore, it's impossible to achieve justice through eye for an eye, tooth for tooth, literally, and you have to use monetary damages to achieve justice in those cases. And likewise here. imposing exile on the conspiring witness would not produce the same consequence for the conspiring witness that it would produce for the one he sought to impose that on, and that's why we have to do something different. That's what I've got for us tonight. With God's help, see you Tuesday at the regular time, 6 p.m. Pacific, and I'll get an answer for why all the tractates start on page 2. All the best. Shavua Tov. Good Vach.